Hi, everyone. So we are here today talking to you about the recent 148 judgment of the Supreme Court that was announced last week. There has been a lot of discussion, a lot of debate on what's going to happen, what did the Supreme Court do. So we are here to talk about some of that. So to give you a quick background, in Finance Act 2021, the reassessment law was overhauled and there was a new provision added, which was 148A. And the whole way the reassessment was taking place was also completely changed. Now, in the earlier law, what was stated was that there needs to be a reason to believe for the assessing officer to issue a reopening notice that income had escaped assessment. Now that mechanism had changed, and now the assessing officer first needs to show cause the assessee, the taxpayer, and give them information pursuant to which the 148 notice could be issued. Now, this law was passed sometime in the end of March of 2021, which came into effect from 1st April 2021. Uh, and now, basis the Relaxation Act that was also passed, during the pandemic to give extension to timelines for issue of notifications. There was a notification which extended the timeline for issuance of notice under the earlier 148 law from 31st March to 30th June. Now, the tax department, using that as the basis, issued notices for reassessment between the period of 1st April and 30th June under the old law, whereas the new law had already come into force from 1st April. Now, considering this, there was a challenge made in various high courts on the reopening notices, and several high courts ruled that the reopening notice is bad in law and should be quashed. The matter went up to the Supreme Court, and the Supreme Court, in its ruling, held that uh, all 148 notices would be deemed to be a 148A notice. It laid down that information and material pertaining to these 90,000 notices would have to be provided to the taxpayers by the assessing officers within 30 days of the judgment being released, which was on 4th May. And it also said that certain provisions of the 148A would be dispensed with for the purposes of this notice. Now, what comes out of this judgment, right? Couple of things. First is that there are about 90,000 notices, which means the assessing officers now need to provide information and material, right? Both of these things to all of the taxpayers within a 30-day period. So the first question that arises is, what happens if the assessing officer is not able to provide it after 30-day period? Does it become void ab initio because you have not followed the Supreme Court's order? Or you have to go back to the high court and tell them that this was not followed and therefore the notices should be quashed. So there remains a challenge, and that remains unclear as to what's going to happen then. The second point is that even in spite of dispensation being given to inquiry, that needs to be done under 148A, there is still a sanction that is required of the respective authority. Now, there is no mention of that in the judgment of the Supreme Court. So again, that remains to be seen what's going to happen there. There was another point on the limitation aspect, which basically meant that because these notices were issued under the previous law, it meant that it could go up to 6 years in situations where the condition under Section 149, which was previously there, was met. But 149 was also amended by Finance Act 2021 and reduced the limitation period to 3 years, and in certain cases to 10 years. Now, by virtue of the Supreme Court's order, even the Supreme Court says that all defenses will be available to the taxpayers under Section 147 to 151. The question that remained was, what's going to happen to all those notices which were issued prior to the 3-year period, which were falling in the 6-year period. And only yesterday, the CBDT and clarity was sought from the CBDT around this, and the CBDT has clarified that the limitation is going to work as per the new provisions, and therefore under Section 149, the 3-year period would kick in, and that's how the notices would automatically be looked at. Now coming to the point on what's going to happen from this point onwards, I think there's been a lot of discussion on whether there is going to be a review petition that is going to be filed before the Supreme Court, or whether that should be filed considering the judgment has been passed under Section 142, under Article 142 of the Constitution, which gives Supreme Court plenary powers, in the interest of justice. Now, a review petition, according to me, in my personal view, will not help, because the judgment provides in itself that the assessees as well as the revenues have actually agreed to the position that the Supreme Court has taken. There is a paragraph in the judgment which actually provides for that. Now, if you do a review petition, then the Supreme Court itself will say that both parties had agreed to this notice is being deemed to be under 148, and therefore why should there be a review required here? So on that basis, I don't think a review petition is going to make too much sense and is going to be entertained really by the court. Now, I think I'll end by saying, we are going to see how this all pans out. There are 90,000 notices. Hopefully, because of the clarification by CBDT yesterday, there is going to be some notices which will be considered to be beyond the limitation period, and therefore, to that extent, those should be quashed and not be considered. But let's see what happens. That's about it from me. Thank you.